The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Welcome. We have 3 cases that will be submitted this afternoon. Those cases are Mark Milligan versus Ottumwa Police Department and the City of Ottumwa. Second case is Larry D. Eisenhower versus the Henry County Health Center and others. And the final case is State of Iowa versus Lori D. Mathis. Now, the Mathis case is now submitted to the court without an oral argument, and we'll proceed to hear the arguments in Milligan. Counsel.
May it please the court. Counsel. My name is Skylar Limkemann. I represent the City of Ottumwa. I'm accompanied here today by Joni Keith, the City Attorney, and the Mayor of the City of Ottumwa. This case concerns an open records request made by Mark Milligan, a former police officer for this city. Mr. Milligan requested the names of violators of the city's ATE ordinance. But just because Mr. Milligan submitted an open records request to the city for what under federal law is confidential personal information does not make him entitled to that information. In this case, the district court erroneously interpreted the Driver's Privacy Protection Act by concluding that the information that Mr. Milligan requested was not confidential and was not subject to federal law. The problem with the court's analysis in this case is, one, the text of the statute expressly provided that the name of an individual was confidential information and could not be released. But two, to make the court's ruling flow, the court would essentially have to rewrite the statute to include words and phrases that were actually not in the statute. For example, personal information to state, but does not include information that identifies an individual on driving violations. That's not what the actual statute states, and that's included in my brief. The statute is very specific, and it includes that the name of a person is confidential information. However, in the next phrase under the statute, it says, but information, and then it goes on to say, on driving violations is not confidential and protected under the statute. However, that word information and the way that it precedes driving violations is a general phrase. Information is not as specific as personal information, which specifically includes the word name. Additionally, the information, if we just look at the dictionary definition, includes facts and data. If Congress wanted to include the name of a violator within the statute, they would have wrote that within the DPPA, but they didn't. It makes sense that they wanted to include information about data and facts, statistical information, for example, under federal law, because that information can be useful for members of the public, whether it be analyzing accident information, whether it be analyzing police response to criminal activity, and that wouldn't offend the notion of privacy that the statute sought to protect when it was enacted.
Can you address the exemption argument that the statute allows for permissible uses by government agencies, and then once the government agency uses it, that becomes a public record at that point, subject to disclosure?
Yes, Your Honor. Just because the government uses that information, whether it be the law enforcement or another government agency, doesn't necessarily make that information a public record. There's a line of cases out there, and this was briefed, but there's a line of cases out there that essentially addresses this issue of when law enforcement uses a record, does that become a public record? And the answer to that question is no, particularly back to the text of the statute, which provides that the person requesting the record has to have an authorized use as well. If that reasoning would flow, just because somebody makes an open records request doesn't mean that the law enforcement agency would have to provide that record. If Congress wanted that to happen, they would have wrote into the statute that the public exemption would be for a records request.
Well, let's say here the records request was for a list of all people who chose to have a municipal infraction rather than the automated traffic citation issued. Would that be permissible to be disclosed?
So you're saying that if a member of the public contacted the city and said, I would
As
like a list
as I understand the ordinance, the automated traffic enforcement ordinance, there's a provision in here that says a person can request to receive a municipal infraction rather than an automatic traffic citation. Is that correct?
That's correct, Your Honor.
So if somebody made an open records request and asked for the names of people who elected to proceed by municipal infraction rather than the automatic citation, would that be subject to being disclosed?
That potentially could be disclosed, Your Honor. That would assume that that information has actually been filed with the court, because once it's actually filed with the court and there's a civil or a criminal action that's initiated, then that would be potentially something that could be disclosed under the statute, and it's no longer protected information. The distinguishing...
And I'm sorry, yeah, exactly. Tell me what distinguishes the the official citation versus the municipal infraction case.
From the facts of this case, Mr. Milligan requested the names of the violators. The only way that we got the names of those violators was through the Inlets database, which is basically the Iowa system where you have the driver's license records. With that, this is different than a police officer going out and issuing a traffic citation to a member of the public, because in that case, we are obtaining their identifying information from them, from their driver's license.
But under this ordinance, you've obtained the identification from Inlets, and now the person who owns the vehicle is electing to proceed by way of municipal infraction in court case versus the automatic traffic citation. So the source of the information for the ticket and the infraction is the same. So why is one discoverable and one not?
I think that the distinguishing factor there is the fact that it's actually been filed as an action within the court, and then potentially could go under the public use exemption for filings in the court.
What do you do, like things like Amber Alerts? You know, they put the picture of the guy up or the gal, and they put the license plate up, and you get in your phone and you see it on these interactive signs. I mean, is the DOT or the state violating the law when they do that?
No, because they're not providing information that came from the Inlets database. That would be something that would be provided by a third party, such as a witness, where they were saying this is the license plate of the individual that we believe to be, kidnapped this child.
Every time there's an Amber Alert, they always have somebody telling them what the license plate is. They don't say, like, John Doe may have abducted this child, and they don't go look up John Doe's license plate or card.
I wouldn't say every time, Your Honor. I would say certainly that there are situations where law enforcement could run a person's name and information to find out what, for example, that individual's vehicle is, and they could put that information out there. I think that that would fall under an exemption under the statute, though, for law enforcement purposes. And I think that that would also fall under the exemption under Iowa Code, just the same, for a law enforcement purpose.
I have a question. Are these automatic traffic enforcement tickets, are they even driving violations? Because I remember with the original challenge to the Davenport ordinance, we argued this was preempted by the Motor Vehicle Code, and this court held, no, it's not, because it's a civil violation, and it's not a moving violation that goes on your driving record. It doesn't count on your driving record. You could have 100 of these things. So does this even fall within the federal exemption for driving violations? Plus, it's the owner of the car getting not the driver.
I would agree with that, Your Honor, but that's an open question because that particular provision has not been interpreted yet to date. The issue I believe that you're pointing to in the case law too is in this particular case with the city of Ottumwa, the driver of the vehicle is not necessarily somebody that we know who that person is. There is a presumption under the law that the person that is actually violating the speed regulation is the driver of the vehicle. However, we don't know who the driver is. We know who the registered owner is because we get the license plate information through Inlets. We don't have a photograph of that person. There's no way for us to go back and identify them, except for in this case, Mr. Milligan was issued a citation through the system because it was the city's police car, and we were able to determine through other evidence that that was Mr. Milligan violating the statute. So I would agree that there are situations where this may not even apply to violations depending on the particular administrative ordinance that enacted it or what the state code is at the time.
But, you know, we say that, or we don't, the cities say, I mean, when you get one of these notices, and I've gotten a few, some mine, some my son's, but they say nothing goes on your driving record. Now, assuming this ruling stands, what's to prevent the car insurance companies from getting together and just serving a general open records request and for all of these citations that have been issued, and then using that for underwriting purposes?
Are you saying that if the person would elect to have a municipal infraction filed against them?
No, I think I'm not saying that. Let me try and be clear. What is to prevent an insurance company doing the same thing that Mr. Milligan did, and serving a blanket open records request, say, you know, to the city of Des Moines, which has the same thing, saying we want all the violations, and then let's say all the insurance companies got together and pooled the cost of doing that and used it for underwriting. What's to prevent that?
Well, I think that there's two issues there. One, I think that insurance companies have access to certain information under the federal statute. I'd have to go back and look at the express text of the statute, but then there's also a use information there, and I know that there's some public safety language in there. I don't know the answer to that question, though, precisely, Your Honor. It's possible, but I'd have to go back and look at the text.
It's meant to be a friendly question. Maybe you're misconstruing it as a hostile one, but okay, go ahead.
Isn't there a statute, though, in Iowa that you can't use it for underwriting these tickets that don't go on your record? Are you aware of that statute? Now, we have the right to speed law, and they all say they can't be used for underwriting purposes on insurance.
That could very well be. I'm not familiar with that statute off the top of my head.
And when you answered Justice Waterman's question, hasn't that been litigated, whether it's a violation or not, in the parking ticket area, where they were putting parking tickets on the car, and courts originally held you can't do that because you're disclosing the name of the owner with the license plate because they had the name, and then they sort of backed down on that one?
There were several cases.
That's really not a violation.
There were several cases that addressed the issue of the parking tickets, and my recollection that you might be referring to is the Sen case from the Seventh Circuit. And with those situations, the disclosure in those cases were inappropriate because they were actually putting the parking tickets with the driver's name, address, everything else out there on the windshield, where anybody could walk by and just grab that citation, open it, and then find out that confidential personal information.
That was a violation. I understand that, but that was a violation based upon looking up someone's license number, not knowing who parked, tag number, not knowing who actually parked there. It's sort of like the automatic traffic cameras.
That's correct, Your Honor. That's correct. There was no person that necessarily saw that individual park illegally, where a police officer then walked up based on the facts that were reported, at least in the opinion, and then issued that person a citation individually. With regard to the actual district court ruling in this case, it's inconsistent with the intent of the Driver's Privacy Protection Act, which was there to protect the privacy of individuals and to ensure that people were not going to do an end around and ultimately gain information that they shouldn't have under federal law.
What does the record show you do with the ones that are not municipal infractions? Isn't it you mail those out to the people?
That is correct,
and
Your
then
Honor.
the city keeps a record of who they mail the bill to?
The notice, yes, Your Honor.
And once you mailed the bill, doesn't that become a public record because it's a bill owed the city?
No, Your Honor, because that is still, it's just like anything else that's sent from the DOT to somebody. The DOT sends notices regularly to members of the public, and that is sent to them individually. That's not made public just because there's a mail.
But you're billing people for a fee. I mean, just like a water bill, just like a dog license bill. I mean, that's public record that you have someone owes you money.
The difference is there, though, how we got that information, and that information came from the database solely because we had that person's license plate information. And to the extent that somebody would request those bills, the confidential personal information would have to be redacted from those records. With regard...
On the public policy argument, I guess I don't understand. So in the world before there were automated traffic enforcement systems, speeding tickets were issued by officers, obtained the information from the motorist at the time of the stop. All of that information is public. The name, the car, the license plate number, etc. So now we have technology, you take a picture. It doesn't seem like there's any additional information that's being exposed if you were to reveal these records than what would have been exposed before you had automated traffic enforcement systems. Is that fair?
I would agree with that, Your Honor, but that goes back to Congress and would be more of an argument for them and would be challenging, the purpose of the underlying statute in of itself. I see my time is running out. May I finish? I think that the issue there is what was the intent of the law, and the intent of the law was to protect the privacy of individuals. With that particular issue there where we have law enforcement physically issuing a citation, that's different because we as law enforcement would be getting the information from the individual driver, not necessarily just getting it from the database. Thank you.
Thank you as well, Mr. Limkemann. Mr. Gardner.
May it please the court. Good afternoon, Chief Justice Cady, justices of this Iowa Supreme Court. Thank you very much for allowing me to argue this case today. My name is Steve Gardner. I'm in the law firm of Denise Gardner and Zing out of Ottumwa, Iowa. And I represent Mark Leonard Milligan, the appellee in this case. It is my estimation, and I jump right in and say, similar to what Justice McDonald was asking questions on, it is my estimation that the central issue in this case is whether a city may exempt from disclosure its traffic tickets that they have enacted a code allowing it to be a civil infraction versus a criminal infraction. In the state of Iowa, every single criminal traffic citation, parking citation, everything is a matter of public record. Can be looked up on EDMS, Iowa Online Services. Similarly,
your points are really fairly persuasive to me. What about the people, as pointed out by the other side? Because part of the open records request was for people who were not ultimately issued these citations, but that were detected by the camera system. What's your argument that you're entitled to that information?
I understand the distinction twofold. First of all, driving violations are specifically exempted from the term personal information under the Driver Privacy Protection Act. And I'm going to call it the DPPA from now on because that's what I'm used to, and it's a heck of a lot easier than pronouncing the whole thing. Iowa Code 321.11 adopts the DPA language identically. It says all information with the Department of Transportation is a public record unless it is confidential under the DPPA.
Could you also serve an open records request, say for all drivers that are issued warnings as opposed to traffic citations?
Haven't thought that one through.
Well, think it through. What do you think?
I think yes. I think if a police officer pulls over an individual and clocks him for speeding, and in choosing to give a warning, which they write with the information on it and issue it to the driver, now it has become a public record. We have to remember, not only does the statute say that driving violations are not personal information. As mentioned, there's 14, that's just an exemption. It's just not personal information. Then there's 14 exceptions to the statute, and the most important one is any information obtained by law enforcement. And when it is obtained by law enforcement, I'll come to the case here in a minute because it's in my brief. It's United States. I'll just say it now. It's McWhorter. It's the United States District Court case out of Alabama, McWhorter versus City of Mobile, and there they held that when law enforcement obtains personal information, the law enforcement exception applies, and that it may be released to the public. And their language was incredible. It says the DPPA is not intended to hinder law enforcement by making certain information confidential. So there's the statute says that driving violations is not personal information, and it also says that information obtained by law enforcement is accepted from the confidentiality of the statute.
Don't you think that there was a bit of a compromise, perhaps, when all of these citations or infractions started coming up, criminal versus civil? Wasn't it kind of a compromise? I think the cities kind of know when they put these machines up, there's going to be a lot of people saying it wasn't me, it wasn't my car. And if there's not the agreement, we won't even call it a moving violation. We're just going to call it. Don't you think there was an intent to kind of maybe take away some of the power of the word violation, that it intentionally moved to maybe a different kind of an area that isn't so common?
I don't think that. And the reason is that there are no defenses to the ordinance. They don't come in and say, I wasn't the driver. They can't under the statute. The only defense is that you didn't give consent to the driver. In other words, that your car was stolen. That's the only defense to this ordinance.
Is this even a use? And I guess I'm kind of struggling with this issue. The federal statute prohibits departments of motor vehicles from distributing this information, and then it has exemptions for permissible uses, correct? You know, having a city use it, using it for law enforcement purposes, etc.
Yes.
So once the city has lawfully obtained the information for the use of traffic enforcement or for whatever reason, is it a use to have to disclose it in response to an open records request? Right? I mean, this is documents and information the city's in possession of. What in the statute prohibits the city from disclosing the information if it's not a use?
I would argue it is a use. They get the information and it loses confidentiality when they get it, if they're using it for law enforcement. And I don't see how you can make a difference between issuing a civil infraction just to avoid court costs to try to encourage people to not contest the charge, and insert as well that there are no defenses to the statute. I don't see the difference between that and handing someone a ticket. And in fact, the ordinance provides that if you want to refuse to pay this and you tell us that, we issue you a citation. So if they issue a citation, it automatically becomes a public record. What's the difference between red speed, sending the information to law enforcement, and then issuing the fine once it's proved? And that brings up a very good point, and that is, as I indicated in my brief, the statute says that it's only confidential if it's information obtained from the Department of Motor Vehicle. Well, Red Speed's not an employee of the Department of Motor Vehicle. It is not a law enforcement agency. It is a privately contracted agency with the city of Ottumwa.
When Red Speed goes to that database, they're acting as an agent of the city of Ottumwa. That's what their agreement says.
I agree. They are acting as an agent of the city.
And then on top of it, once Red Speed sends the information to Ottumwa, am I right that Ottumwa then goes to the database themselves, confirm that's the person? I saw that somewhere in the record.
I don't believe so. I believe the record is that they get it and they decide whether to approve or disapprove the issuance of the civil fine. And then they send it back to Red Speed, and then Red Speed sends the picture and the fine directly to the driver, not from the city of Ottumwa. Red Speed sends them.
Can you cite any case to us that has held that a one of these camera tickets or ATE photo enforcement tickets is a driving violation within the meaning of either the federal statute or the Iowa Motor Vehicle Code?
I cannot cite a case to that, but that is because not once across this country has a state or a municipality claimed that a speeding violation is confidential information under the statute. It's never been raised before. First time in the country. Bottom line is, I return to what I started with. The question is, if the Ottumwa Police Department issues a ticket, it automatically becomes public record. The question is it confidential because they have adopted an ordinance that merely allows it to be a civil infraction against the owner? Is it then just confidential because the city has adopted the ordinance allowed by statute and is held by their school?
You know, I understand that once they file a municipal infraction, that's a public record, but I'm having trouble with the other part of your request for information that goes to the names of people who were not issued citations.
My example would be this. A charge does not have to be filed for the law enforcement information to lose its confidentiality. And the examples are, I order, in fatality cases in the state of Iowa, I order technical investigation reports from the Department of Transportation, which is not the Department of Motor Vehicle. And I think it's $5. For $5, I can get every last piece of information about the drivers of the vehicles in that fatal accident. Similarly, if there's a motor...
Is there a separate statute, though, governing those accident reports?
There's a separate statute in Iowa, but there is not a separate exclusion under the DPPA.
You only get those because you have a business exception, and the DOT, and maybe you didn't do it, but when I practiced, I had to fill out a form that I was doing it to investigate accidents in connection with my business, and that's one of the exceptions under the DPP.
We do not have to do that. All we have to do is send a letter with a check that says, please provide me with a copy of the TI investigative report. Another example would be motor vehicle accident reports. There's another statute in Iowa. I can go get a motor vehicle accident report from the Department of Transportation anytime I want concerning anyone I want, and it contains all the information regarding the drivers involved in that motor vehicle accident.
Mr. Gardner, let me ask you about that hypothetical I asked Mr. Limkemann about, the one involving the situation where, say, insurance companies get together and decide, well, maybe we'll serve open records requests on all the municipalities that are doing this so we can use this as underwriting information. What would there be to prevent that, if you're correct?
if the insurance company requested that information, I believe it's public record under the DPPA and 321.11. I think they get it. You know, a lot of the cases that have been decided under this DPPA involve lawyers soliciting the names and addresses and personal information of people involved in motor vehicle accidents so they can send out solicitations. And almost universally across the country, it's been held that that's acceptable. I believe the only place that has held otherwise is the state of Illinois. Before I move on to just the other brief issue, I think it instructive when you look at the League of Cities brief in this case is they cite the Wren case, which is probably the leading case in the country, recent case in the country, Arkansas Supreme Court, where they held this information is this identical type of information is not confidential. And the League of Cities position was, well, that decision was just wrong. I urge this court to look closely at the Wren decision and at the McWhorter decision, as I think they're extremely instructive on the analysis that should be made in this case. With regard to the court's decision, we ask the court to affirm on the issue of on the conclusion that this information is not personal information and is not confidential under federal and state law. I'm going to address, I've got attorney fees. It's an abuse of discretion. It must be unreasonable. The district court is an expert. This court has decided dozens upon dozens of attorney fee cases and attorney fee claims, and I will rely upon your reasoned judgment. Again, thank you very much for the opportunity to speak with you today.
Mr. Gardner, thank you as well. Mr. Limkemann, may I present your rebuttal?
Can you
Mr.
clarify one thing for me? Does the city of Ottumwa go back to the database when they get the thing from Red Eye?
Do they go back to the database,
Yeah.
the inlets database again?
Yeah.
My understanding of the record is that once the information is initially received from the inlets database, that comes to the city, and then once the city says, yes, issue a citation, then that would go back to RedSpeed, and the database is not reconsulted.
Okay, but the city does look at the database.
Correct.
Okay,
Correct.
not Red Eye looking in the database.
No, the RedSpeed folks, when that goes, they are accessing the inlets database and providing that information to the city through there's a portal, basically, electronic portal.
Does the city then recheck the database?
I don't know the answer to that question, Your Honor. Okay. I believe that the officer does check the database to verify that the information is consistent.
I thought I saw that on the record, but I'll have to find that myself again.
I want to address.
Can I ask you just a quick question? Of the cases cited in your brief, can you point me to the one or two best ones that deal directly with open meetings, open records / FOIA requests versus litigating issues of permissible uses and affirmative disclosures?
Well, I don't think we get to the point of the open records litigation side of this because the DPPA applies. I think that it's just like what we were talking about in the ACLU case.
Is there a case that says a state or municipality does not have to disclose information that may have been obtained lawfully from a motor vehicle department?
I think that the Marriott case, the United States Supreme Court case, slightly addresses that issue, Your Honor, but I also believe that there are several other...
Is that a FOIA case or an open records case?
That was a case that was brought by the attorneys requesting records basically to solicit clients. There was another case and that was the New Richmond case from Wisconsin, and that was a Wisconsin open record statute concerning accident reports. But the difference with that case and this case, Your Honor, is there was a specific Wisconsin statute that provided that those records were public records. And there was a side issue in that case where the Wisconsin court indicated that the origination of the information was key, and there's a fact dispute about whether the information that the law enforcement agency had came from third parties outside of the database. And I think that that's a distinguishing factor here is we 100% know that the information that we got, including the names of the individuals, came from the Inlet's database. Some of these other cases, there's two different lines of cases, and some of these other lines of cases have an issue there where they were gathering information that came from, a motorist on the side of the road or some other source of information. I want to address one issue that was raised. These municipal ATE ordinances, they've been quite controversial, but there is no doubt that when the city sends the notice to somebody, that is a lesser category than a municipal infraction. It's a lesser category than a criminal citation. There is no doubt about that because it does not go to the record. Frankly, if nobody knows about these particular notices going out except for the person receiving them. Then like with your son, you might say to him, I received this in the mail, were you driving on this date, this time? But other than that, there's no way for anybody else really to know about that. And now the difference becomes when the city would file that as a municipal infraction or as a criminal citation from a police officer, that then makes it a public record at that point in time. I want to address one thing that Mr. Gardner said about the information becoming public immediately upon receiving it from the Inlet's database. That is not true, and that is completely inconsistent with the Driver's Privacy Protection Act. The information, that would defy logic because we could have a police officer that's out in the parking lot right now going through and running license plate numbers, and then as a member of the public, I could submit a records request to the police department and say, I want to know the name of every single driver that the police officer ran on September 19th, 2019 in the Iowa Judicial Branch's parking lot. That would defeat the intent and the express text of the statute. We have to look at the statute and its text and stay consistent with that text and the purpose. With regard to the attorney's fees issue, I just want to address 2 points. The district court in this case essentially rubber stamped the attorney's fee award application. The $57,000 is much larger than the average of $38,000 for the median income for residents in the city of Ottumwa. It's an issue that the court needs to scrutinize closely, and I see my time is running out. Thank you.
Mr. Limkemann, thank you as well. Mr. Gardner, thank you again. The case of Milligan versus Ottumwa Police Department is now then submitted, and we'll next hear the arguments in Eisenhower versus Henry County.